Mojo made this.
Speak in support of the Consumer Law Reform Bill. And I think it's extremely timely that this is one of the last bills that were passed in 2013 in the House before Christmas, that this law will be in effect by then, a law that gives greater protection to consumers. Several speakers before me have commented on the inordinate length of time that it's taken for this legislation to come through the House. So we're very pleased to see it here. When I've spoken previously about the bill, I've spoken about the very strong support that we have for the fact that this bill, despite substantial opposition from major businesses, that it has retained the unsubstantiated representation clause. And I've talked about greenwash and about health claims and all sorts of other claims that are being made on products without fact to back these claims. And I was just going through some of the submissions that the big businesses and so on have made against this clause. And it struck me just how many had opposed this clause, that had opposed the fact that they should be able they were arguing that they should not have to have evidence to back their claim. And these were companies like Meridian Energy, Contact Energy, banks such as ANZ, Westpac, the Direct Selling Association of New Zealand, the Association of Advertisers of New Zealand, Business New Zealand, Wine Growers New Zealand, the New Zealand Food and Grocery Council. All of these really lobbied the committee to arguing that the current law would provide adequate protection. And the kind of comments that they were making included things like, basically it would not take consumers much effort to go and look up whether the claims were true themselves. And I mean, it was absolutely ridiculous that consumers should have to go away and try and find out or work out for themselves whether claims on a product are true or not. And that's just patently not fair on the consumers to be expected to do that kind of extensive research. I would really struggle to do that for many of the claims that are made. And like many consumers, I would like to be able to believe that when a company makes a claim on a product, when it makes a claim that it might be more effective in cleaning the carpet, for example, that you would expect that claim to be true. And it's not actually physically possible to test some of these claims on your own account unless you rely on other groups who have done that research, such as Consumer New Zealand. And they were good, but I do want to single out that there were strong submissions also made supporting the clause on behalf of the consumers. But there is one company that did actually support in favour of retaining the clause of unsubstantiated claims, and that was Mighty River Power. And I would like to quote from their submission because I thought that that showed a very high level of corporate responsibility. I said, Mighty River Power supports the proposed prohibition on unsubstantiated claims. We take great care to ensure that all of our claims can be substantiated. It is important to us, from both a legal and a marketing perspective, that consumers trust the claims that we make. Fantastic. I just wish that all the other companies had been as positive and as proactive about their statements as Mighty River Power was, because that was showed corporate responsibility, and I was dismayed at all the other submissions that were made by so many other companies arguing against that clause. And I very much respected the committee for withstanding that lobbying by all these different companies and leaving the clause in the bill. Although we have amended it so that obviously untrue exaggerated claims can still be made, such as that you might make you fly or something like that. And so that straightforward, simple expectation that you do not make a claim on a product unless you have some evidence to back that claim. And why is that so important? Because the status quo prior to this has been that it's been up to the Commerce Commission to provide evidence that a claim is false. And that is costly and time-consuming. And this way, by reversing the onus onto the company to provide evidence that their claim is true, saves a lot of time and effort on the part of the Commerce Commission. And that ultimately costs the taxpayer. And the Commerce Commission cannot investigate every claim and produce the level of evidence that's required to take it to court when claims are false. So by reversing the onus of proof, it makes it much more straightforward. And it's not like it's going to be a huge compliance cost. It will be because just don't make the claim. Just don't make it if you don't have evidence for that claim. We were concerned that there were not powers given to the Commerce Commission to be able to have the power to enforce unsubstantiated representation effectively. And so we wrote to them and asked them, did the bill contain a sufficient power for them to be able to enforce it? And they wrote back and they said that yes, we do consider effectively that they do have sufficient powers, particularly since they can now request evidence for written evidence. And they have information gathering powers in the Act that will give them assistance. And so we are hopeful that the bill will work as it should on this clause. If it does not, then we will obviously have to reflect on that further down the track as a body of case evidence appears. The other thing that is very important to realise about this bill is that it gives protection to consumers wherever they purchase the product, whether that's online or offline. And as we move into more information technology age, this is incredibly important that they have that protection everywhere. Thank you.
Sam Lodoinga.
Thank you, Mr. Speaker. Speaker, to please